Hey, so this video is about who should or shouldn't take the necessary steps to avoid probate. I'm Paul Rabelais. I'm an estate planning attorney. I'm here in Louisiana, help people all around South Louisiana, and even help a few folks from North Louisiana. But this video is, a lot is discussed about it. This topic of whether people should have a will or trust, whether they should take the steps necessary to avoid probate or not probate. So let's, take a little bit closer look at that. This issue gets clouded sometimes by some people who are more biased. Give you a couple examples. We've seen in the last, decade or two how some people in the financial services industry really push the living trust and even sell the living trust so they can discover all of the assets that somebody owns, because when you have a trust, those assets need to be retitled. The more the financial advisor finds out about what you own, the more they can hone in on selling annuities or life insurance to you. That's not the case with every person in the financial services industry. Just like the legal profession, there's a lot of really good people and then there's the bad ones. But we've seen a lot of people advocate living trusts for the wrong reasons. On the other side, we see sometimes people in my profession, the legal profession, say, oh, no need to have a living trust because the probate is not that bad. Most of those words are heard from people who make a living taking families through the probate process. And so they say, no problem, probate only costs X. But I've seen those same lawyers take families through a probate process and incur costs and fees in excess of 20 or 30 times X. So it gets a little clouded there. So let's just try to be objective. I've come up with 7 reasons why people should take the steps necessary to avoid probate, 3 reasons why they shouldn't. Real quick, I've done a podcast on this particular topic. Check that out. Estate Planning with Paul Rabelais is the name of the podcast. It's 27 minutes long. This video is designed to be brief. Real quick, if you own property in multiple states, the Louisiana probate doesn't transfer property you own in other states. If you own all that property in your name, your family's going to have to go through multiple probates, multiple states, multiple sets of lawyers. Kind of a nightmare. Put all those assets in a trust. Avoid the probates everywhere. Second, not really a probate issue, but a lot of people have found that, some people say, I'm going to keep my assets in my name, and if I become incapacitated, I got that covered. I name my son as my power of attorney. He can do everything for me. Well, a power of attorney is only as effective as the third party is willing to honor it. A lot of financial institutions have said, we're not going to honor the power of attorney that son is presenting to us because it's too old. It doesn't have the right word in the title. It doesn't have the right whatever. They don't want to work with 2 people. So because of that, some third parties don't honor powers of attorney. But if you have a trust, I've never seen a circumstance where, when properly done, the successor trustee, upon the initial trustee's incapacity, can step right in and make transactions. So be wary. Powers of attorney are only effective as the third party is willing to honor it. We got to do something about that. The third reason is people who just want to reduce the post-death cost and trouble. So just finished working with a gentleman and his wife, and he realized that if his estate went through probate with the statutory 2.5% executor's fee, that's not even getting into the attorney costs, there would be a 6-figure executor's fee under that statutory executor's fee that takes place when there's a succession or a probate. So he designated a trust, a CPA family member who says it's going to be easy and it's going to be just a fraction of the cost. So some people want to eliminate all the executor fee, attorney fee, court fee stuff that's required, and so they see the financial benefit there. 4, if there's the potential for conflict. Maybe dad has several children, they don't get along. It's not a fair statement to say a will can be contested and a trust can't, because if you do it wrong or you don't have the required mental capacity, or if you're unduly influenced by someone, all of those things, if done incorrectly, can be challenged. But generally with a trust, the settlement goes quicker. All of the participants don't have to be involved in the trust settlement. They just have to receive the trust assets. Or if you have a probate, everybody's a participant. They're having to sign off on different things, and there's the potential for, unnecessary delay. Some people want to have a trust because they just want to plan ahead. We see a lot of people, they have children out of state, children raising families. They just want to do as much as they can ahead of time to make it easier for their survivors. Those people typically choose the trust because they, just want to plan ahead and make it easier. Had a gentleman tell me once he owned a business. He said, every day that goes by after I die, my business is going to be worth less because my business relies on me. So that relies on me. That business is going to need to be sold immediately. Having that business in a trust allows the successor trustee to continue transacting, sell that business immediately. Some people who own a business want their business in their trust to avoid all the delay that goes when the courts have to oversee that. And then maybe just the final reason is some people just want to make it easier. They're like, I want to make it as easy as I can on my wife. She's not real savvy with the financial stuff. And if I can arrange it where she doesn't have to do anything or deal with lawyers and courts after I pass away, I want to make it as easy as I can on her. So those people often, set up the trust to avoid the probate process. 3 reasons why you may not need to do that. 1, in Louisiana, we have something called a small succession affidavit procedure. If what you own is worth less than $125,000, equal to or less really, then, and if you're comfortable with the way our laws say things must go, if you die without a will, then, and it's dangerous to say this, don't have anything in place. Don't need a trust because your estate can pass under this outside of the formal probate proceeding, small succession affidavit procedure. And your children, for example, will really almost immediately get what you have. So less than $125,000 and comfortable with the intestate laws. If you have a will, this small succession affidavit procedure is not available. I've done another video on that. Also, if there's not going to be any probate anyway, then no need to form a trust to eliminate probate. And probate is not going to be necessary if, for example, you don't own a home, you don't own any real estate. Maybe all you own is your IRA, where you've named beneficiaries, your bank account, where you've arranged it by adding an adult child as a signer, filling out a payable on death designation at the bank so that people have access to it when you pass away. So if you don't have any probate assets, no need to set up a trust to eliminate the probate. And then the third reason why it may not be necessary to do this is some people, kind of funny, come in and they just say, I don't care, I'll be dead. And so, I just want to make it as simple as possible on me. I want to leave everything in my name. Sure, I'll do a will. Yes, when I die, whoever I'm leaving these things to, they'll have to go through probate. I don't care. I'll be dead. Want to make it as simple as possible on me. I don't care how difficult it's going to be for them. So there you have it. A few pros and cons of, why you should, why you shouldn't. I mentioned it a few minutes ago. If you want to know more, check out our podcast, Estate Planning with Paul Rabelais. You'll get a much longer version of this discussion. It's about 27 minutes, and we go through it in more depth. There you go. Hope this helps. Make sure you take care of your business. The worst thing to do is just ignore it. Get yourself with the right estate planning attorney who can walk you through things, get it right the first time. Go Tigers. Have a great day.